versus State of Maharashtra. It's a case of the year 1984. This is the citation. You know how to read the citations? This is the year 1984. This is the journal, All India Reporter. This is the page number 1622. Now this judgment is also reported in Supreme Court rulings, which is 1985 SCR. It is volume 1, page 88. So this is how citations are written. It's a landmark judgment on circumstantial evidence. But why is it a landmark? What does it lay down? Facts of the case, Aishwarya can just read it for them. What are the facts of Sharad Veddi's in Sharda?
Facts of the case in brief are, in this case, one woman, namely Manju Shri, was found dead at her husband's apartment. As this is a criminal case, here one party is Manju Shri's husband, Sharad Veddi Sharda, with two co-accused, his uncle and his brother. Uncle's name is Mr. Ram Vilas, brother's name is Mr. Rameshwar. And another party is State of Maharashtra. State of Maharashtra, why? Because the crime took place in the state of Maharashtra. So basically, state is the prosecutor in all the criminal cases. So any crime that takes place is a crime in rem, right? It's not, civil cases are crime in person, like they are in personam. Crime is always in rem, like against the society. Then the cause of death of the victim, Manju Shri, was found to be potassium cyanide. This is a poisonous substance, and this was found in her autopsy report. So basically, in post-mortem report, the viscera of the victim was preserved, and from that viscera we came to know that potassium cyanide has been used for poison, which is the cause of death. In this case, accused got convicted and pronounced, and life sentence was pronounced by the High Court of Maharashtra, where petition filed by the Supreme Court through SLT, Article 136 of Indian Constitution. जब High Court से सजा हुई तो फिर Supreme Court में गए. वहाँ पे बेसिकली लॉ ले डाउन हुआ कि सर्कमस्टेंशियल एविडेंस को कैसे असेस करना है, हाउ डू वी रीड इट, हाउ डू वी असेस इट, व्हाट category and what quality of circumstantial evidence should be in order to establish guilt of the accused. Alright. So now basically this case provides a wide explanation of circumstantial evidence, which became landmark decision in the area of evidence law.
So what has been laid down, they are known as the golden principles of circumstantial evidence. Now the first principle is, we can start from the intern. Each one of you has to read one principle. What is the first principle laid down? बैठ के बताएं. What is the first principle laid down in Sharad Veddi and Sharda's case? The circumstances. Right. So you cannot say, for example, if a boot mark is found on the soil, it may or it may not belong to the accused. That circumstance should be fully established. For example, it belongs to a boot. The boot is not made in India. The boot is probably purchased from Oxford Street in England. Crime is committed in Lucknow. Nobody else has this kind of a boot in this vicinity except the accused person. If it is a Bata shoe, there could be millions of people in India wearing that same shoe. So you have to prove the exclusivity of that circumstance. Or the circumstance could be whether the firing was made from a particular pistol or not. Now the laboratory says, yes, the marks match the pistol, which is a licensed weapon of the accused person. So probability of anyone else firing from that pistol is ruled out. Or fingerprints found on the weapon completely corroborate with the fingerprints of the accused. There should be a conclusive report of the forensic laboratory. So the first thing is, circumstances from which the conclusion of guilt is to be drawn should be fully established. The word is conclusion. You remember what I told you? Clues, inferences, conclusion. Now we are talking about conclusion. When you are going to hold somebody guilty of murder, will all either sentence him to death or punishment of imprisonment of life throughout his life. You should be sure that it is fully established circumstance. Now the next guideline?
The facts to establish should be consist only with the hypothesis of the guilt of the accused. That is to say, they should not be explainable on any other hypothesis except that the accused is guilty.
Okay, so did you understand this? Some facts are getting established, but they should prove the guilt of the accused, and there should not be any other explanation for it. For example, if you remember the flower vase which is broken and a cat sitting there, was there an earthquake? Was there a tremor? Was it placed just on the margins? It could have fallen down on its own, or were there other cats in the room? So again, this means that there should not be any other hypothesis. There should not be any other possible manner in which the crime was perpetrated. So it should be consistent only with the hypothesis of the guilt of the accused. Somebody dies by poison. It is to be proved that the death by poison was by administration of poison. It was not accidental, it was not suicidal. Is it clear? Which is the third guideline? Somebody raise the third guideline.
Circumstances should be of a conclusive nature and tendency.
Alright, did you get it? That the circumstances should lead to a conclusive nature and tendency, meaning thereby that they should not be simply clues, they should not be simply inferences, they should be conclusive in nature. Suppose one circumstance is the DNA analysis. Now DNA analysis should establish that the DNA recovered belongs to the accused only. There should not be a probability. In one of the cases which I would be narrating to you, they could not recover the DNA. So they go on to recover what is known as a mitochondrial DNA and compare it with the mitochondrial DNA of the mother of the deceased. Now there is a very bleak and a remote possibility, because if our DNA is compared with any lady's DNA, the probability is that they could match. It's so common. So exclusivity element is also very important. Like fingerprints, they say fingerprints is something which is exclusive. But mitochondrial DNA, there is an element of probability. So as a matter of abundant precaution, you should look for corroboration. So it should be conclusive in nature. Fourth one.
Every possible hypothesis except the one to be proved.
So you know the theory of exclusivity, excluding. What we said, there are three suspects. So first we have to exclude the involvement of suspect B and C. Only then you can prosecute A. You cannot have a case where you are just prosecuting, charge sheeting A, whereas you are nurturing doubts about the involvement of B and C also. We'll mention a case, we'll mention this IIT case in this context later. Next.
There must be a chain of evidence so complete as not to leave any reasonable ground for the conclusion consistent with the innocence of the accused, and must show that in all human probability the act must have been done by the accused.
Now I want the other two of you to also read this paragraph, because this is the ratio. So read it again. We all should again focus on each word.
There must be a chain of evidence so complete.
Wait. So there must be a
Chain of evidence.
What is meant by chain?
The evidence links that we talked about, that you told us about.
So there must be a chain of circumstances.
Yes. So like for example, the DNA must match, there must be a murder weapon linked directly to the accused. The foot, like as you talked about, if there is a footprint, so that the accused should have that particular shoe in question.
So there should be many different circumstances and connected with links like a chain. You must have seen what a chain is. I mean, it could be an article of jewelry also. So they are all connected. There should not be any link broken. If a link is broken, it will cease to be a chain. So the most important thing is there must be a chain of evidence. Now what kind of chain should be?
It should be complete.
Complete. Azhar, you read that further. As not to
leave any reasonable ground for the conclusion consistent with the innocence.
So this is, there should be a chain of circumstances. It should be complete. And there should not be any reasonable ground for the conclusion consistent with the innocence of the accused. Now there are two things coming up. There are circumstances. He has also made a chain. The prosecution has also made a chain. Is it sufficient? No, it is not sufficient. There should not be any reasonable ground for the conclusion consistent with the innocence of the accused. So there should not be any ground for the conclusion consistent with the innocence of the accused. Let me give you an illustration to make it clear. Very recently, after serving probably about a decade in jail in US, a professor has been acquitted. Right? A professor has been acquitted. What was the charge? The charge related to bombing of a train in Europe. It was alleged that the professor who was in US is guilty of bombing a train in Europe, and he remained in jail based upon circumstantial evidence. But what was the circumstance? What was the circumstance? The circumstance was near the bombing site. His DNA was recovered from this. That was all. He maintained that he never left America. He had never left America. He had never been to Europe. The prosecutor is saying, we are finding your DNA at the site of the bombing. You are the only one who would have done it. His daughter has also written a book on it. So, what had happened and why he was acquitted? You have been ordering things from Blinkit, Amazon. You order goods, right? You order goods, you return articles. From our fingers, if somebody has that problem of this cutaneous tissue oozing sebum, our DNA gets caught up on those paper bags. This was a problem. He had ordered certain goods, he had touched it, he had carried it, his DNA got transferred to that bag. The same article was used by somebody in Europe. Some goods were delivered, and that bag containing his DNA also, apart from others, was found at the site. So whereas we say that witnesses may lie but circumstances do not. But then what is the check laid down by our courts? Not to leave any reasonable ground for the conclusion consistent with the innocence of the accused. They overlook the fact that this man has never left the shores of America. How could he be involved in a bombing in Europe? And like gospel truth, they believed upon the presence of DNA on an article to prosecute him and put him in jail for more than a decade.